Mr. Lloyd, you're at Oakland County?
Yes, sir.
Just so I know I can do all of it.
Brandon.
No, he said they study seeing.
He said he's out.
I think it has to be, all the time.
Oh. You don't like to get.
Yes, that's the easy ones. Maybe hour, the one like. Ones that are. Like this one was. Yeah. This Oh, I never, yeah. My efficiency. It's funny though, that's good thing, he has made on my way.
All right. Can 14th court back in session?
Have a seat, people. All right, Lloyd, appearances for Lloyd.
Good morning, Stephen Gafford on behalf of
And good morning, Judge Oakley, good morning to your staff, and for the defendant service, Carrie Martin, P. 592, our representative, Mr. Philip Lloyd, he is to my left, Mr. Lloyd, take it from me.
Thank you. We ready to get started? Please.
They had a count of possession of a firearm while under the influence of liquor, it's 90 misdemeanor, of course, depending.
Understood. First witness. Watch your step on my ramp. Raise your right hand. Swear affirm, tell the truth, the whole truth, nothing but the truth.
Swear.
Yeah, can you lose a hat?
Yes, sir.
Thank you. Have a seat. When you're ready, Mr. Cavill.
Nick, state your name, sir.
Officer Zachary Sequenda.
Are you employed?
I am.
Work for the police department, Ms. Ramos? How many years have you been a police officer? How do you spell your last name?
SCICLUNA.
Officer, were you working on March 29th of 2025 at about 1 in the morning?
Yes, sir.
Did you have the occasion to be at a Simcoe gas station in Romulus?
Yes, sir.
Remember the address?
5820 Middle Belt.
That's in Romulus? Sir, during your course of duties on that evening, did you meet a gentleman named Philip Lloyd?
Yes, sir.
If you saw Philip Lloyd again, did you recognize him?
I will.
Look around the corner and let Judge Oakley know whether you see Philip Lloyd.
I do see you, Philip Lloyd. Here, sir.
What's he wearing?
He is wearing a orange shirt with a white undershirt.
Noted.
Identify defendant Philip Lloyd.
So noted.
Thank you, Ron. Are you wearing uniform or plain clothes?
Either one.
Well, sir, where do you meet Mr. Lloyd?
I'm sorry.
Where do you meet Mr. Lloyd, Philip Lloyd?
I met him at the Sitco gas station.
Why were you at the Citgo gas station?
The gas station clerk called us there for a person harassing.
No object at this point to any statements made by Citgo gas clerk.
Set out for the truth of the matter asserted, she could be the biggest liar, she could be Pinocchio. Fact is, the employee is giving the police officer information, whether it's true or false, he can act on it. So, Senator, set out for the truth of the matter asserted.
Well, I'm not even sure that a foundation is laid, the statement was made to Officer Sequenda or that Officer Sequenda heard the content of the statement.
And that's because there was an interjection before I asked.
I'll let you lay foundation.
Speak at the gas station.
It was a dispatch call from.
Did you receive the dispatch or was it another officer?
The dispatcher received the call and they put it over the radio to my unit.
Did you talk to the dispatcher?
Over the radio, yes.
So what information were you given about the Citgo gas station?
The gas station had called referencing a black male alert.
Again, I'm going to object, so now we're into double hearsay, we're into.
Or not hearsay at all if it's not issued, introduced for the truth of the matter asserted. Which it's not. It's introduced to establish why he went to the Citgo. So I'll overrule the objection. You're welcome.
Yeah, why did you go to the Citgo station?
We were dispatched to the gas station for a male harassing customer.
Were you given a description of him?
I was,
What description were you given?
in my report, if I could look at.
With reviewing the report, refresh your memory?
It was.
Judge, does he have permission to review this report?
Absolutely.
About your own.
Please.
Yourself, sir, and let us know when you've completed your closing. Thank you. Is your memory revived?
It is.
Officer, what description were you given?
I was advised there was a male wearing a black sweatshirt and black pants.
Did you notice anybody at the Citgo station matching that description?
Yes, sir.
How many people did you see at the Citgo gas station at one in the morning matching the description provided me by dispatch?
Just the one, sir.
And who was that person?
Philip Lloyd.
Did you learn from Mr. Lloyd his name? How did you gain Mr. Lloyd's name from Mr. Lloyd?
I asked him.
You asked him what?
I asked him for his ID. He advised he did not have one and identified himself by word of mouth.
Sir, Do you eventually gain his name though, Philip Lloyd?
Yes,
How do you gain that name?
he told me his name.
When he told you his name, what steps did you take, if any?
I wrote it down in the lien search of Mr. Philip.
When you asked Mr. Lloyd his name, had you arrested him first?
No,
Had you handcuffed him?
no,
Had you placed him in custody?
no.
Did you threaten him in any way? Well, armed with the knowledge that you had a man named Philip Lloyd near you or with you. Well, by the way, where is he at the gas station when you see him?
He is sitting on the walkway of the gas station
Outside or inside?
outside.
Armed with the information that this person might be Philip Lloyd, what steps do you take?
I conducted a lien search of the person named Philip Lloyd and confirmed that it was him with the photograph that lien/SOS provides and
SOS as well.
Secretary of State.
But what did you conclude after reviewing the Secretary of State form?
I found out that he had warrants for his arrest.
As a result of learning that Mr. Lloyd had warrants against him for his arrest, what did you do?
Placed him in handcuffs and arrested him.
Find any firearms?
Yeah.
Where?
It was in his right sweatpants pocket.
What?
The revolver, the Smith and Wesson revolver.
What did you do with that weapon when you noticed that it was confiscated?
My partner took it to the rear of the patrol vehicle and made it safe.
Now, sir, did you attempt to determine whether this defendant, Mr. Lloyd, had a valid and current CPL on the date of this incident?
I did. I not only asked him, but I asked my dispatch to run in for a CPA as well.
When you asked Mr. Lloyd whether he had a CPL, how did he respond?
He advised that he did not have a CPL.
What information did you gain from the lien whether Mr. Lloyd possessed a valid and current CPL?
I learned that he did not have a CPL.
Sir, are you in a position to tell Judge Oakley about the state of sobriety of Mr. Lloyd when you encountered him?
Object as to relevance, it's not relevant to the charge element.
I'm seeking that account of possession of a firearm while under the influence of alcohol.
That would be a misdemeanor count for which neither the people nor the defense has right to a preliminary exam.
That is not correct. He doesn't have a right to a preliminary examination on that count, but I have to still prove it because it's not included in the original complaint. Or I can move to amend the complaint and say on the count, and then you don't have to make findings. Do it either way, whatever you prefer.
I'll allow it.
What conclusion, if any, did you read about the state of sobriety of this defendant?
When we first approached him, I noticed he was unsteady, had an unsteady gait, and eventually needed a garbage can to steady his balance. When approaching him, the odor of intoxicants was emanated from this person.
Can you estimate for Judge Oakley the number of drunk driving capers you've been involved in as a police officer?
Did you just say caper?
That's a prize, isn't it?
It worked.
Mark, you guys. Have you?
More than 5?
And what conclusion did you reach as to whether you're sober or not?
I saw he was not sober.
Thank you.
Mr. Martin, your witness?
Good morning, Officer Spuna.
Morning.
So a few questions for you.
Hold on a minute, Kerry, I'm sorry. Pronounce your last name.
Secluded.
Okay, it's pronounced as if it was S-I-C.
Yes.
Okay, all right, because I was never sure if it was Scaluna or Cicluna. So now I got it right. Okay, thank you. Go ahead.
So, just briefly, you say as of now, you've been a police officer for about 1.5 years.
That's correct.
So as of March 29th, 2025, the day of this incident, how recently had you become a police officer?
So I graduated the academy November 11th.
November 11th of 2024.
Correct.
Thank you. And then immediately you joined the Romulus Police Department? Okay. And then as of that time, you mentioned that in your career, you've done more than 5 drunk driving investigations. How many do you think you had done as of March 29th, 2025?
I'm not sure.
So, as you just to confirm what you stated on direct, your dispatch to this location, the gas station, But at that point, you had not spoken to any employee or citizen who was at the gas station, right?
That is correct.
And the information you received from dispatch, it didn't describe crime taking place at the gas station. Wouldn't you agree?
I was dispatched to a male harassing customers at a gas station.
Harassing, but that's not a report of an assault, right?
Correct.
Not a report of trespassing.
Correct.
And you didn't have any more detail beyond the word harassing.
Correct.
So you and your partner pull up to this gas station in a fully marked patrol car.
Correct.
You and your partner are both fully uniformed.
Correct.
And as soon as you pull up, you and your partner hop out of the car,
Step out of the car.
step out of the car, and you immediately see the person later identified as Mr. Lloyd outside the gas station.
That's correct.
You never go in the gas station,
That's correct.
and there's no one else outside, right?
That's correct.
So you don't see him interacting with any other person.
At the time, that is correct.
You don't see him committing anything that would be called harassment. And you don't observe any sort of, bulge consistent with a firearm at that time when you first see him, right?
That is correct.
Okay. And you see him, but you didn't recognize him from any prior interaction, no?
I did not recognize him.
And as soon as you see him, would you agree that your words to him were, "What's going on? Come here."
That sounds correct.
Yes. And so at that point, you've given him an official order to come towards you, right?
I would say so, yes.
Yes. He's not free to leave at that point, right?
In the circumstances, I would say yes.
Thank you. And this is at the point where you're giving him that order, you don't yet know this person's name, right?
Right.
You don't know anything about what he has warrants. You don't know anything about intoxication,
Correct.
right?
So we
And-
can follow.
When you say those words, "Hey, come here," his body at that moment, he was kind of walking away from the front door of the gas station. Would you agree?
That's correct.
Okay. Safe to say he was not approaching you when you made that order, right?
Correct.
Okay. But then as soon as you make that order, he submitted to your order and came to you and your partner, right?
Yes.
At that point, you began questioning or interviewing some kind of. And so when you eventually discover this firearm, that's due to a search incident to arrest on the warrants, right?
Yes.
Okay, it's not some sort of, you don't perform a Terry frisk prior to arresting him on the warrants. You never performed any sort of field sobriety tests on him, right?
That is correct.
No breathalyzer
Correct.
and no blood draw that you're aware of. I have nothing to.
Victor, have you responded to other calls involving harassment?
I have.
And give us a range of different types of harassment cases you've investigated as a responding officer.
I have to object to this question on relevance grounds, or speculation. I don't see how other harassment, calls that Officer Skuna has responded to could possibly be relevant to this case, where all we've heard is that dispatch told him harassment with no further details.
So it's counsel who raises the issue about, he calls it harassment, it's harassment. But he's the one who raises about harassment. What was he doing? Did he commit a crime? I now have a right to elicit for you, the finder of fact, what harassment can mean. It's not as though he's there selling cookies. Here, somebody filed a complaint and he's investigating. Harassment could be a touching, it could be profanity, and we also know he's under the influence. He has the right to determine who this person is.
And
That's called to the scene.
I just want to briefly respond that Mr. Kaplan said this person filed a complaint, that's not really true. All we know is that there may have been the 911 call, but nothing about filing a complaint, which is a formal process.
I think the court can take judicial notice and apply common sense here. 911 called him. Somebody obviously called the 911 dispatcher. She didn't drive to the gas station to fill her tank during the day or at night. So I want to know what harassment can mean to him, because it gives him the right to investigate.
I'll allow it.
Harassment, if you have cases involving harassment clause,
I,
and give us the range, tell us what types, we don't need an hour, soliloquy, but what types of cases are we talking?
I've responded to harassment cases involving constant contact over the telephone, constant unconsensual contact in person, a wide range of harassment cases.
Thank you.
Any recross?
No.
Also, you can step down. Watch your step on my ramp. Any other witnesses?
People risk.
Any defense witnesses?
No.
I'm ready for argument, fellas.
Notice, we always do, we didn't present any proofs regarding felon and deception of firearms. It's not as though it's bad, yes, we all proofs. Without going into large details here, we don't have proof at this point to show that the gentleman, Mr. Lloyd, was a felon in possession of firearms. We asked the Your Honor to bind the case over on 2 counts. We know it's unusual and misdemeanor, but carrying a concealed weapon and possession of firearm while under the influence of liquor, that's a 90-day misdemeanor. So what do we have here? We have an officer on patrol with a partner wearing a uniform and a marked scout car, and he receives a call from dispatch. Now, that is very common. That's how they communicate. Dispatch says there's a guy at the gas station harassing people, something along those lines. And a description is given, not only of the gentleman's race, but his height and what he's wearing. Officer arrives, sees a guy, one guy, not 100, not 50. He sees the defendant. Defendant is outside. It's close enough to him at some point to see he's under the influence of liquor. Now, Terry v. Ohio allows an officer to stop, detain, and question a person when there's reasonable suspicion that he might have committed a crime, attempted to commit a crime, or is about to commit a crime. And at this point, in 1 a.m, they see a man who allegedly has been harassing people. They have a right to investigate. He asked them a simple question: "What is your name? What is your name?" And he doesn't have a licensed judge, but finally he says, "It's Philip Lloyd." And guess what? Mr. Lloyd has warrants against him. So they arrest him, they search him, they find the guns. There's no Fourth Amendment violation there. We seek a minor vote.
Mr. Martin.
Thank you, Judge. So first to address what Mr. Kaplan just said about some of these counts, they're now looking to bind over on 1, 2, 4, or 5. So of course, defense moves for dismissal of those counts.
Done.
Furthermore, I'd like to address the added count next, this proposed misdemeanor, which Your Honor did allow Mr. Kaplan to ask questions regarding that count on his exam. So if I may offer some counter argument, even Mr. Kaplan having the opportunity to make a record of this misdemeanor count, the only record he made is possible observations of suspected intoxication in a case where there's no field sobriety tests, no breath, no blood. I mean, we're speculating here. This isn't a driving case, so those things wouldn't exist. So this person has never met Mr. Lloyd before, doesn't know his disposition, doesn't know anything about his mental health. So I think that we're grasping at straws here, and that count should not be bound over. Now, finally, if I can turn to the remaining felony CCW count, where we are objecting to bind over on Fourth Amendment grounds, as Mr. Kaplan alluded to, I believe that there is a Fourth Amendment violation here. If I can just explain what that looks like, I think that the controlling case here would be the California versus Hodari T case from the Supreme Court. That citation is 499 U.S. 621. That's a 1991 case written by Justice Scalia. And that's really the case that stands for the proposition that when does a seizure occur? If an officer has not used physical force on someone, if an officer gives an order that says, "Hey, you stop," and that person runs away, that person has not been seized for Fourth Amendment purposes. But if an officer gives an order, says, hey, you stop, and it's a lawful order, the person then submits to that show of authority, that is the moment of seizure for Fourth Amendment purposes. It's really a question of, does this person feel free to leave in that situation? And we even had Officer Sakuna agreeing that once he's given a lawful order to Mr. Lloyd, that Mr. Lloyd is not free to leave. So let's think about what is known to the officer at the time when he gives that order, that seizure. He doesn't know Mr. Lloyd's name, he doesn't know anything about Mr. Lloyd having warrants. He sees Mr. Lloyd walking away from this scene. He doesn't observe Mr. Lloyd committing any crime. He doesn't observe Mr. Lloyd near anyone else. He doesn't observe any of this harassment. He doesn't have any details about what might have occurred inside the store other than this singular word of harassment, which standing alone is not really wrong. So under Hodari D, he doesn't have what he needs yet to seize or detain Mr. Lloyd. And even if we look at it under the framework of Terry, which Mr. Kaplan referred to, Terry versus Ohio would require reasonable suspicion that Mr. Lloyd is armed and dangerous at that time. And we had testimony that there was no observation of any sort of firearm-shaped bulge. So there's nothing in the report saying, hey, this man is harassing people and he has a gun. There's nothing like that. So there's no reasonable suspicion that he's armed. And I think that alone should cause it to fail. How many Terry cases have you seen where it's based on suspicion that a person has a gun? That suspicion did not exist here until he's being searched incident to arrest on these warrants that were, again, unknown at the time of this Fourth Amendment seizure. So that's why I do believe there's a Fourth Amendment problem here, and that the evidence seized, namely the firearm, is the fruit of a Fourth Amendment violation, and therefore the case should not be bound over. Thank you, Judge.
You're welcome.
So I too am familiar with California versus Hodari D. And in that case, there's a young man, a young male, the police see him, he sees them, and he runs away. This defendant runs away, and the police run after him. And the court says, there's no seizure. There's no seizure. He ran away. Now, in this case, I'd like you to imagine we live in a world where under these circumstances, an officer has to say, oh, I see this guy. He matches the description of somebody who allegedly was innocent people at the gas station, and I can't do anything about it. Hey, nice to see you, officer. Nice uniform. Have a good life. That's not the case. The police have a right to investigate. It's 1 a.m. There's a harassment call. It can only be one guy. He matches the description. If he can't say to him, hey, come here, what's your name? I don't want to live in that world, because that would mean that many of the arrests that the officers made, many of the collars they made, many of the stops, they're not good. They're not good. This case involves reasonable suspicion based on the time of the day, the actions of the defendant, and I'm not even sure asking somebody's name is a inquisitorial matter. We all have a name, and ask them his name.
I'll give you another shot.
I would say we're thinking about, how do we avoid a situation where every single interaction like this is a Fourth Amendment violation? Well, a police officer in that situation can arrive at the scene and do more to investigate before they start telling people to come to them and implying that they're not free to leave. Obviously, the officers could have entered the gas station first, tried to find out who made this call and learn some more information. Instead, they see a single person, gives him an order, and at that point start investigating when they've learned nothing about what happened. So I think that they went about this wrong.
I just want to make sure I understand the argument, Mr. Martin. Because I think what your argument is that based on what they got from dispatch alone, they did not have enough to investigate the gentleman they saw outside the station.
If you think about, my argument is when they say, hey, come here, that is a seizure for Fourth Amendment purposes.
I think we would all, I don't think you're disagreeing to that, are you?
No.
I think we all agree that was a seizure.
That's a secret.
Yeah.
So what's the lowest standard in Fourth Amendment law?
Right.
Reasonable suspicion. So is there reasonable suspicion at that time? So if it's, and there's reasonable suspicion for Terry's purposes, that's armed and dangerous, I don't think that's met.
I would agree.
For reasonable suspicion also appears in the traffic stop context, reasonable suspicion of a traffic violation. That's obviously not present here. Reasonable suspicion of a crime, I don't think that that's relevant either. And in fact, that's.
Hold on. Let me stop you there because I think we all agree that's where we disagree. You think there was reasonable suspicion of a crime triggered at that point. You don't. Am I right?
I would modify someone reasonable.
Go ahead.
Had committed a crime, attempted to commit a crime, or is about to commit a crime.
Fair enough. Fair enough. Do we agree that's where the split is between you two?
I agree with that.
Okay, go ahead then.
One more piece of law on the record.
Sure. Yeah.
Sorry, I didn't have this at the ready, but there is, a piece of, Michigan law, and I'm trying to find the correct MCL, that talks about the circumstances where an officer is authorized to make an arrest. And while I'm fumbling for the exact citation right now, it is when circumstances where there's no warrant, there's a piece of Michigan law that says that an officer may arrest when a felony or misdemeanor is committed in their presence, or if they have reason to believe that a misdemeanor of a certain severity was committed even outside of their presence. And under that law, I don't think that the standard is met here either.
I would agree with you. Yeah, I think the question is whether or not, based on the dispatch call only, they had a reasonable suspicion. Because you don't think they do without more investigation before they seize.
I agree. I think it'd be different if the dispatch call said he's intimidating other customers and making them feel unsafe. I mean, that might be reasonable suspicion of some sort of assault or threat, or he's been told to leave and he's not leaving, reasonable suspicion of a trespass. But this scant amount of detail, and we don't have dispatch records. I mean, they could have brought in the CAD report from the 911 call and have someone authenticate that. I don't even have that in discovery. So we're just not going off of enough here. When you're making someone feel not safe to leave, well, just go into the gas station, talk to the clerk, learn some more information first. So then you're doing this investigation based on personal knowledge and not just stopping people on the street based on this extremely undetailed, unspecific report that you got through the dispatch.
Mr. Kaplan,
If we accept.
I'm loving this, by the way, so I thank you both.
We accept this premise, it would mean they could not hold him, they couldn't ask him anything, they would have to go into the gas station and conduct an investigation, so to speak. Who called? What was it all about? In the meantime, guess what happens to the defendant? He's gone. He can run away under Mr. Martin's theory here. He doesn't have to stay. But when we say, stay here, we're gonna investigate what happened in the gas station, that would be a seizure. That's not what happened here. When you put on your rope this morning, you didn't leave your common sense behind. The fact is, it would be misconduct on the part of the officer to say, hey, you know, I'm leaving. I have other things to do. I want to stop at Dunkin' Donuts. That would be misconduct in office. He probably would lose his job if he just said, let it go. He has to investigate in the way he did. Hey, what's your name? How incriminating is what's your name? How many of us have outstanding warrants as this man did? He's the one with the warrants. He's the one who didn't show up at court. He's the one where the officers have to arrest him when they learn about the warrants.
All right, thank you, gentlemen.
The MCL I was looking for is MCL 764.1.
764.
So the U.S. Supreme Court of Governments happens here, not Michigan State.
All right, thank you, gentlemen. I'm gonna bind over on count 3 only. I understand your argument, Mr. Martin, that the dispatch call that there's a black male wearing a black hoodie and black pants that's been harassing customers is not enough detail, but I think it is enough detail for an investigation. And I don't think an investigation that starts with what's your name is onerous. So I'm gonna bind over only on count 3. I agree with your argument on the under the influence carrying a weapon. Any other clarification for the record?
No, thank you, Judge.
All right. Officer, can you come up?
How often have you been on stage? That was the first. You did a great job. Thank you. Great.
Business like, yeah. I figured you didn't have a lot of experience.
Was that who said?
I just told him I thought you did great. Yeah. Be safe, fellas. All right, so I didn't say this, Mr. Martin. I'm sorry, just for the record, AOI is next Tuesday, 9 a.m. Good luck downtown.
If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.